Welcome to a new NYLESA podcast episode. Our guest is Suneeta Dewan, senior partner at Chugh LLP, a New York-based law firm. Suneeta is an immigration lawyer with 15 years of experience working with UN clients. Suneeta has already recorded a podcast on immigration for our association in 2019 that you can find on the NYLESA webpage. Today, we will focus solely on opportunities for UN spouses related to the E-2 visa. Before we begin, I would like to remind us that the different experts interviewed for the NYLESA podcast express their own point of views, and NYLESA doesn't endorse or recommend their services. Having said that, Suneeta, thank you for taking the time to do this podcast and for sharing your expertise with us.
My pleasure, Julian. It's always a pleasure to work with the UN community, and more recently, I've started working with the World Bank. So the international organizations have a very interesting group of people, and that makes our job quite pleasurable. So I look forward to speaking to you and giving you some information on the E-2. I have been an attorney for 25 years and specialized in the field of immigration, and close to 16 years with the UN staff. I'm often asked by UN staff what the options are if they are not eligible for a green card via the special immigrant provision, and what their options are if their spouse, who's the primary G4 holder, leaves for an assignment and the family wishes to stay behind. There are several options that I had given a bird's eye view on in my first podcast, and what I plan on doing in this podcast is give you the option of an investor visa, like an entrepreneur visa, known as the E-2 visa, which is a popular one for people from international organizations. The E visa is a non-immigrant visa for investors from treaty countries. There are about 78 countries, member nations, that have signed on to the treaties. There are two treaties, the FCN and the BIT, that the nations have signed on to with the US. The FCN stands for Friendship, Commerce, and Navigation, and the BIT is the Bilateral Investment Treaty. Nationals of these countries are eligible provided the criteria that I'm about to discuss now are met. The E-2 is a popular visa, as I said, from qualifying countries, and it is given to people who wish to invest in, to develop and direct their own businesses in the US. And what they mean by develop and direct is basically to own in large part and to actually operate the business. Now, this must be distinguished from the EB-5 visa, which is the immigrant visa, giving people the opportunity to get a green card directly, but that requires a minimum investment of $900,000 in certain geographic areas and $1.8 million in certain other geographic areas. That is not what we're going to be talking about today. I know that most people don't have that sort of investment, and therefore that is a very limited option. The E-2 requires a sum that is much more manageable. But first of all, what does it mean to be a national of a treaty country? It merely means that you have a passport from that country, not that you were born in the country. So if you are a national of one of the 78 countries, you qualify. If you are not a national, but you're interested in the E-2, you may still qualify by becoming a national of one of the 78 countries. Now, there are two that are particularly popular these days. One is Grenada and the other is Turkey. It's fairly easy to get nationality of those countries. And by virtue of getting nationality there, you can get the E-2 and come to the United States. To get access to the list of countries, the US Department of State website is the best place to go. And that is www.travel.state.gov. It's too lengthy a list to go over today, right now, in this podcast. So I'm going to let you go to the website. Now, there are two sets of people that are eligible for the E-2, investors and employees. An investor is one who must be entering solely to develop and direct the treaty company and must have control over the treaty company. An employee, on the other hand, must share the same nationality as the controlling owners of the treaty company and may enter in the US to act in an executive, managerial, supervisory, or as an essential employee capacity, and must have the qualifications to assume such a position. For purposes of this podcast, we will simply focus on the investor. If there are listeners out there that are interested in knowing more about the employee segment, we ask that you contact us and we can consult with you on a one-on-one basis. The first requirement in order to be eligible is that the investment be substantial. In order to qualify, an individual must have invested or actively be in the process of irrevocably investing a substantial amount of capital in a bona fide, real, and actively operating enterprise. Now, what does it mean for an amount to be considered substantial? This varies based on a sliding scale, and it is typically assessed in relationship to the total cost of either purchasing an established enterprise or establishing a new enterprise. Generally, the investment amount should be sufficient to ensure the successful operation of a business. There is no bright line test. Generally, an applicant should be prepared to invest at least $100,000, unless it's in a consulting business, in which case a lot less may be needed. What the USCIS does in this assessment is use a proportionality test. And this is used to compare the total amount invested with the cost of establishing a viable enterprise. The percentage of investment decreases at a gradual rate as the cost of business increases. So, for example, if the cost of business is $100,000, 85% to 100% investment would be required. If the cost of business is more than that, let's say 500,000 to 3 million, 50% or sometimes even less could work. The second important element is that the investor have control over the US business. Now, control is established by ownership of at least 50% of the enterprise. And this is commonly evidenced by the amount of stock that the person owns. Often, people enter into partnerships and joint ventures, and those also qualify, as long as the investor has operational control. One way of evidencing operational control is maintaining management, having a managerial position, and making decisions in running the business. The third requirement is the source of funds. And here it is very important that the source of the funds be lawful. Now, the source of funds need not come from outside the US. They could be savings from income earned in the US. They could be personal savings, investment earnings, gifts, inheritance, etc. Certain types of loans also qualify. So, for example, a loan secured by the investor's personal assets will qualify. There is equity in a home and the person takes out a second mortgage, that would qualify. However, if the loan is secured by the assets of the enterprise itself, it will not qualify. The investor has to have control of the funds, and the investment must be put at risk in a commercial sense, which means that it cannot be invested with a guaranteed return. It's important that the investor put the money at risk and run a legitimate business. The best strategy is to have the investor transfer the funds into the e-visa company from his or her own account. Now, the question that most investors will ask, and it is a common concern, is what happens if the visa is not approved? Now, what the CIS does accept is that the assets that are used for the purchase be held in escrow, and those can be released or transferred once the visa is issued. It can be made conditional upon visa issuance. However, the business must reach a point of being actually operational and merely in the contract phase. So there is a fine line that the investor is walking here, where some amount of funds should actually be invested. Others can remain in escrow until such time as the visa is issued, in order to ensure that one is not risking the funds should the visa be denied. Although once the funds are invested, the business is operational, and if it is to a large degree operational, there's a very high degree of success because the monies would have been put at risk and that element will have been satisfied. The fourth requirement is an important one as well. Even though the applicant may have made a substantial investment, the CIS, the Citizenship and Immigration Service that I've been referring to, wants to make sure that this is not a marginal investment. So the investment should not be just enough to generate income to provide a living for the applicant and the family. The idea is that the revenue generated should be greater so that there is some employment created in the US market. If this is not immediately apparent, the economic impact is looked into. And what the economic impact does is it looks to see if the enterprise will generate 3 to 5 or more employees within a certain period after the visa issuance. And the period that they are normally looking at is about 5 years. So if in a 5-year time horizon, there is the possibility of employing 3 to 5 US workers, that should satisfy this element. A comprehensive business plan with detailed projections is key to satisfying this requirement. This is essential and this must be done very thoroughly. One-person companies are not looked at favorably. Now, what are the examples of good e-visa businesses? We've seen a lot of success in retail stores, consulting businesses, restaurants, hotels, dollar stores, gas stations, franchises, could be a Dunkin' Donuts, Subway, any of them. Now, how long is the e-visa valid? The e-visa may be issued for up to 5 years, depending on the specific country reciprocity rules. However, the E is an interesting visa in that there is no finite term. It can be renewed indefinitely. And each time it's renewed, it's renewed for 2-year increments. The 2-year validity is granted typically upon each entry from abroad. And even if the entry is within just a few days from expiration, the individual will have the 2 years based upon the reciprocity table with the country that they are from. Now, how does one get this e-visa? Should the person go to a consulate overseas, or should a person change status here? Now, you could do either. The e-visa can actually be applied for directly at a US consulate abroad, which is good for those who wish to return to their countries, who may want to go back home for a short while and then settle affairs there and come here. And then there are others who want to change status here from their current G4 status or whatever other status they may have. And the change of status is also permitted. The change from a non-immigrant status of a different kind to E-classification within the US takes approximately 3 to 5 months currently. However, a change of status approval does not constitute a visa approval. So when this individual leaves the country, he or she will have to go to a consulate to have the visa processed and stamped on the passport. The spouse and children up to the age of 21 of the principal e-visa holder are also eligible for derivative e-status. Now, what is interesting here is that the spouse of the e-visa holder is entitled to apply for an EAD, an employment authorization document, which is valid for part-time work, full-time work, and work anywhere. It's an open market work authorization that allows the e-spouse to even start his or her own business. So there's a lot of flexibility there for the spouse. There is one interesting requirement, though, which the investor or employee must keep in mind, and that is that at the time of the visa issuance, the person may not have immigrant intent. So he or she has to have non-immigrant intent, which means an intent to eventually return to the home country. Now, even though the person may have sold his home and his other assets in his home country, it's okay, so long as there is an intent to eventually return. And that is key at the time of the visa issuance. Now, there are a lot of nuances that are dependent on the country that the individual is coming from. For example, if somebody is coming from the UK, there is a residence requirement that the individual have resided in the UK for a certain period of time before applying for the e-visa. And so there are these nuances that one would have to look into in greater detail as we assess each case. So that is about the investor e-visa option for UN and other international organization staff that wish to remain here and possibly run a successful business. Thank you.
Thank you, Suneeta. I have a couple of questions, if you don't mind. Why is the E-2 visa so interesting for a UN spouse compared with another visa that might also allow him or her to stay in the US and have a business?
Okay, the reason the E-2 visa is better than any other visa is because there is no other visa that allows somebody to stay here and do business as an entrepreneur. This is really the only visa. The other visas are for employment. There is the H-1B visa, which requires that the individual find a job and be in a specialty occupation, be paid wages that the Department of Labor requires them to be paid, and there is a limited number of visas, H-1B visas, and typically the number runs out within 1 month of the opening of the fiscal year. So the H-1B has its limitations. The O-1, which is another good option for UN staff members and spouses, if they wish to remain, is again one that needs an employer. And the O-1 also requires that the individual be of extraordinary ability. And the threshold to reach that extraordinary ability can sometimes be quite daunting. So the E-2 doesn't have the Department of Labor wage guidelines, does not require an employer, just requires a reasonable investment and an amount that is considered reasonable for that type of business. So it could be, $75,000 for a hair salon. It could be $50,000 for a consulting business. It could be $100,000 for a restaurant. So it varies depending on the area, the size of the business, and so on. So the flexibility and the freedom is enormous.
Okay, got it. Another question. You said that the E-2 is a non-immigrant visa. What happens if, after some years, the UN spouse, for example, which E-2 visa holder, finally decides to stay longer in the US? The fact that it's not immigrant visa, does it mean that it cannot apply for a green card while having an E-2 visa? Or how can it become immigrant?
Yes, that gets into certain technicalities. There are some options which we could consider depending on the individual situation, but that gets a little technical, but it can be done.
Another question, you said that the purpose for this visa for the US government is, of course, to have a business that extends beyond just what the UN spouse might need to live, and so hire people. You said at least 3 to 5 workers in a 5-year period. But you said they were US workers. Does the nationality of the people you hire have an impact on what you can do with the visa? Or is it you can hire anyone on the US soil?
Basically, it's looked at more favorably if you hire a US worker. And by a US worker, they mean anybody who's a US citizen or a green card holder. The idea of all these investor visas is that it creates employment for US workers.
Okay, understood. I don't think I have other questions for you right now, but of course, if some other members are interested in that, they will reach out to you on their own behalf. So, well, it was very informative. Suneeta, thanks a lot for this.
Feel free to, call or email me, and I'll be happy to answer their questions.